Legal system and justice. European Union law, treaties of the European Union, and Charter of Fundamental Rights of the European Union. The European Union is based on a series of treaties. These first established the European Community and the EU, and then made amendments to those founding treaties. These are power-giving treaties which set broad policy goals and establish institutions with the necessary legal powers to implement those goals. These legal powers include the ability to enact legislation which can directly affect all member states and their inhabitants. The EU has legal personality with the right to sign agreements and international treaties. Under the principle of supremacy, national courts are required to enforce the treaties that their member states have ratified, and thus the laws enacted under them, even if doing so requires them to ignore conflicting national law and, within limits, even constitutional provisions. The direct effect and supremacy doctrines were not explicitly set out in the European treaties but were developed by the Court of Justice itself over the 1960s, apparently under the influence of its then most influential judge, Frenchman Robert Lecourt. Court of Justice of the European Union. The judicial branch of the European Union is formally called the Court of Justice of the European Union and consists of two courts, the Court of Justice and the General Court. The Court of Justice primarily deals with cases taken by member states, the institutions, and cases referred to it by the courts of member states. Because of the doctrines of direct effect and supremacy, many judgments of the Court of Justice are automatically applicable within the internal legal orders of the member states. The General Court mainly deals with cases taken by individuals and companies directly before the EU's courts, and the European Union Civil Service Tribunal adjudicates in disputes between the European Union and its civil service. Decisions from the General Court can be appealed to the Court of Justice but only on a point of law. The European Public Prosecutor's Office is an independent body of the European Union (EU), established under the Treaty of Lisbon between 22 of the 27 states of the EU following the method of enhanced cooperation. The European Public Prosecutor's Office investigate and prosecute fraud against the budget of the European Union and other crimes against the EU's financial interests, including fraud concerning EU funds of over 10,000 and cross-border VAT fraud cases involving damages above 10 million. Fundamental rights. The treaties declare that the European Union itself is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities. In a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. In 2009, the Lisbon Treaty gave legal effect to the Charter of Fundamental Rights of the European Union. The Charter is a codified catalogue of fundamental rights against which the EU's legal acts can be judged. It consolidates many rights, which were previously recognized by the Court of Justice and derived from the constitutional traditions common to the member states. The Court of Justice has long recognized fundamental rights and has, on occasion, invalidated EU legislation based on its failure to adhere to those fundamental rights. Article 2 of the Charter of Fundamental Rights affirms the right to life in the EU. Signing the European Convention on Human Rights, ECHR, is a condition for EU membership. Previously, the EU itself could not accede to the convention as it is neither a state, nor has the competence to accede. The Lisbon Treaty and Protocol 14 to the ECHR have changed this. The former binds the EU to accede to the convention, while the latter formally permits it. The EU is independent from the Council of Europe, although they share purpose and ideas, especially on the rule of law, human rights and democracy. Furthermore, the European Convention on Human Rights and European Social Charter, as well as the source of law for the Charter of Fundamental Rights, are created by the Council of Europe. The EU has also promoted human rights issues in the wider world. The EU opposes the death penalty and has proposed its worldwide abolition. Abolition of the death penalty is a condition for EU membership. On 19 October 2020, the European Union revealed new plans to create a legal structure to act against human rights violations worldwide. The new plan was expected to provide the European Union with greater flexibility to target and sanction those responsible for serious human rights violations and abuses around the world. Acts European Citizens Initiative. The main legal acts of the European Union come in three forms: regulations, directives, and decisions. Regulations become law in all member states the moment they come into force, without the requirement for any implementing measures, and automatically override conflicting domestic provisions. Directives require member states to achieve a certain result while leaving them discretion as to how to achieve the result. The details of how they are to be implemented are left to member states. When the time limit for implementing directives passes, they may, under certain conditions, have direct effect in national law against member states. Decisions offer an alternative to the two above modes of legislation. They are legal acts, which only apply to specified individuals, companies or a particular member state. They are most often used in competition law or on rulings on state aid, but are also frequently used for procedural or administrative matters within the institutions. Regulations, directives, and decisions are of equal legal value and apply without any formal hierarchy. European Ombudsman. The European Ombudsman was established by the Maastricht Treaty. The Ombudsman is elected by the European Parliament for the length of the Parliament's term, and the position is renewable. Any EU citizen or entity may appeal to the Ombudsman to investigate an EU institution on the grounds of maladministration, administrative irregularities, unfairness, discrimination, abuse of power, failure to reply, refusal of information, or unnecessary delay. Emily O'Reilly has been the Ombudsman since 2013. Home Affairs and Migration Area. Freedom, Security and Justice and Citizenship of the European Union. Since the creation of the European Union in 1993, it has developed its competencies in the area of justice and home affairs, initially at an intergovernmental level and later by supranationalism. Accordingly, the Union has legislated in areas such as extradition, family law, asylum law, and criminal justice. Prohibitions against sexual and nationality discrimination have a long standing in the treaties. In more recent years, these have been supplemented by powers to legislate against discrimination based on race, religion, disability, age, and sexual orientation. By virtue of these powers, the EU has enacted legislation on sexual discrimination in the workplace, age discrimination, and racial discrimination. The EU has also established agencies to coordinate police, prosecutorial and immigration controls across the member states: Europol for cooperation of police forces, Eurojust for cooperation between prosecutors, and Frontex for cooperation between border control authorities. The EU also operates the Schengen Information System, which provides a common database for police and immigration authorities. This cooperation had to particularly be developed with the advent of open borders through the Schengen Agreement and the associated cross-border crime.